Plaintiff appellant, please step up. On calendar number 16, Whitfield v. Law Enforcement Employees Benevolent Association. Good afternoon.
Good afternoon, Your Honors. Appellant, Plaintiff John Devine G. Whitfield, pro se. Your Honors, I'm gonna keep this pretty brief. This is a very unique case. Here we have a motion to dismiss that was granted, and there is clear-cut proof in the record that the pleading in which this motion to dismiss was based on wasn't even considered. If you look at the judge's May 23rd, 2023 decision in order, he didn't even consider ECF document number 14, which is the First Amended Complaint. And I found that to be very kind of like unique, because I didn't find any cases that says that a motion to dismiss can be decided without actually determining and reading the pleading in the case. Also, I would like to also note, Your Honor, that this would kind of tend to explain why Judge Richard Velasquez relied upon and injected blatant misrepresentations made by defense attorney into this decision in order. It was several blatant falsehoods, outright falsehoods, that I pointed out to the judge that these are falsehoods, and even suggested that this defense attorney should be, brought up in front of a departmental disciplinary committee for making these kind of false statements in a moving papers. And another very unique fact in this case, Your Honor, two of these named defendants are currently standing right now convicted of federal criminal fraud. They were found guilty for stealing almost over $500,000 from the union, as well as from the retirement accounts of members. And all of this was presented to Judge Velasquez, and he literally just glanced all over this. I'm assuming that because I'm a pro se litigant, I'm not an attorney, obviously, and I guess these are the things that happen to pro se litigants when they go to the court process. But in any event, Your Honor, another very unique fact in this case is that I presented the court with a 64-page complaint, Your Honor, that complied fully with CPLR 3016, which requires that any kind of fraud case is explained in detail. So I did that. I made sure that I meticulously presented my whole case. I practically put my whole case on the table just with hopes that it would avoid this from happening, but I guess that didn't really make much of a difference. And in short, Your Honor, I will say that this is a classic illustration of a wrongful denial of my right to my day in court. Your Honor, I had a due process right to a day in court. Against defendants who victimized me as a fraud. I was a fraud victim. And in short, Your Honor, I want to close out by saying, if there's no further questions from the court, could the court please reverse and remand to a different judge?
Thank you. We have your argument.
Thank you. Have a good day.